Welcome to the new Civil Liberties Alliance and to our latest episode of Lunch and Law. Today's discussion will focus around the cert petition that NCLA has filed in the Baldwin v. U.S. case, where we represent Howard and Karen Baldwin. Here to moderate the discussion on that case is my colleague, litigation counsel here at NCLA, Dynar. He will introduce both of our speakers today and get the conversation started, and we'll have time for a Q&A at the end as well. Thank you, Adi.
Thank you, Mark. I first of all want to thank you for being here at the New Civil Liberties Alliance. Today's discussion topic is going to be the questionable future of the Brandex Deference Doctrine. As some of you know, Brandex Deference is one of the government litigant bias doctrines that is the core mission of NCLA to address and tackle at some point. And there is no better case, I think, than the Baldwin versus United States case that's pending in the US Supreme Court that promises to maybe take a hard look at Brandex deference. So I want to introduce our distinguished guests and speakers. We have with us in the room Robert Carney. Bob has more than 3 decades of tax controversy experience representing Fortune 500 multinationals. He offers guidance to clients on managing potential corporate tax risks, implementing best practices for corporate tax planning, and advocating for their rights in tax litigation and administrative tax controversies. He has represented corporate entities before the Internal Revenue Service, with the Department of Justice, and in federal courts across the nation. He is currently an adjunct professor in the Master of Tax program at Georgetown University Law Center, where he has taught tax practice and procedure, both litigation and administrative, for over 25 years. Please join me in welcoming Bob. And with us from California is Robert Keister. He's the managing partner of Chamberlain and Keister, which is in Encino, California. He has been a practicing litigator for over 25 years. He has been focusing on insurance coverage, on professional liability litigation, and representation of business clients in their corporate and transactional matters. He has practiced before the U.S. Tax Court, with the U.S. District Courts in California and Arizona, and in the Ninth Circuit. And he has a long list of appellate cases where he has obtained substantial victories for his clients. And he has also been representing Howard and Karen Baldwin, and has graciously partnered with us in representing the Baldwins in the U.S. Supreme Court. So please join me in welcoming Rob. Thank you for being here. So as Mark briefly mentioned, today's topic is going to be focused around the Baldwin versus United States case. This is a case in which it's seemingly a simple matter of filing a tax document, but it has the potential of taking down the Brandex Deference Doctrine. So I want to turn to you, Rob, and ask you what happened in this case. You have been with this case from the very beginning, and you have seen the case develop and evolve. So tell us what happened.
So what happened in this case is that Karen and Howard Baldwin are independent movie producers. And in connection with their movie production company, they had written off a fairly substantial amount of capitalized film expenses relating to their 2007 tax year. And what that did, because their production company was a subchapter S corporation, allowed them to flow those losses through to their individual return and resulted in a net operating loss carryback that afforded them the opportunity to claim a refund of approximately $170,000 for their 2005 tax return. So in June of 2011, the Baldwins filed via U.S. mail their 1040X 2005 amended return, seeking recovery of approximately $170,000. The IRS took the position that they never received the amended return and therefore denied that claim on the basis that the Baldwins could not prove that it was timely filed. Now, that return was not due to be filed until October 15th, 2011. So the Baldwins placed that tax return in the mail approximately 3 months before it was actually due. After the IRS denied the claim for refund on the basis that it was not timely filed, my firm, on behalf of the Baldwins, filed a tax refund claim in the Central District of California seeking recovery of that $170,000, which was overpaid with respect to their 2005 tax year. And so the primary issue in our case was whether or not the Baldwins could utilize what has been commonly referred to as the common law mailbox rule to establish that they had timely filed their 2005 amended return. That rule provides that when a person, and this isn't limited to taxpayers, but when any person deposits in the U.S. mail an envelope or letter that is properly addressed to the party that it is being sent to and which contains the proper amount of postage, that that letter or envelope shall be deemed to have been delivered in the ordinary course of business, which is normally 3 to 4 days after it's mailed, depending upon where it's being sent. Now, the government has taken the position that the only way that the Baldwins could prove timely filing of their amended tax return was through either sending it registered or certified mail, and relied upon a Treasury regulation that actually became final after the Baldwins mailed their return at issue in this case. And so the issue was whether or not Internal Revenue Code Section 7502, which created what's commonly referred to a statutory mailbox rule, was the sole basis upon which a taxpayer could prove timely mailing. The issue resolved in the district court in the Baldwins' favor was whether or not the Treasury regulation, which purported to repeal the common law mailbox rule, was valid. And in the district court, we prevailed after a bench trial when the district court found that 7502 was unambiguous, was clear, and that Treasury's attempt to interpret that regulation as being the sole means by which a taxpayer could prove timely mailing was improper, and therefore the Baldwins could prove through the common law mailbox rule that they timely filed their amended 2005 return. That judgment in favor of the Baldwins was then appealed by the government to the Ninth Circuit, and in the Ninth Circuit, the three-judge panel found that because Section 7502 did not specifically state whether or not the common law still applied, that there was a gap that the Treasury Department could fill, and that the regulation was an appropriate measure to fill that gap, and that under Brandex, even though the Ninth Circuit had previously found that 7502 did not repeal the common law mailbox rule, that the Treasury had authority under Brandex to actually issue a regulation that overruled prior Ninth Circuit precedent, which had held that the common law mailbox rule still applied even after enactment of Internal Revenue Code Section 7502.
I think, Rob, you touched upon several important themes that we hope to explore today. The thing that caught my attention really with this case is that there's a statute that clearly says that you can use U.S. mail to file a tax document. Now, I assume all of us have filed taxes at some point, so we should be familiar with filing taxes or tax documents.
Don't raise your hand if you haven't.
Yes, please don't. But all of us file taxes, and there is a statute that says how that's supposed to be done. The statute says you can use U.S. mail, which means you can use several different ways for filing tax documents. You can use regular U.S. mail, you can use registered mail, you can use certified mail, you can use international mail if you're an expat. You can use parcel service. There are all sorts of ways in which you can file something with the IRS, and the statute says that. And here what's happening is the IRS is then stepping in and reducing the number of methods that you can use to file a tax document. So IRS came in and said only registered mail or certified mail can be used to do these things. And if there's any dispute at any time with your filing, then you can only use the registered mail receipt. So it's that green piece of paper that some of you may have seen that proves the postmark date. And here, of course, the Baldwins had filed the tax by using regular mail, so obviously they don't have the envelope to prove the postmark date. They don't have the forever stamp that's canceled by the post office with a stamp to prove the postmark date. So in those circumstances, we have a centuries-old rule called the common law mailbox rule that allows us to prove the postmark date by using extrinsic evidence. So the evidence in this situation won't be the actual envelope. It would be testimony. It would be sworn affidavits. It would be someone who goes on the stand and says, I swear to tell you the truth, and I put this letter in the mailbox on June 21st. So that's the evidence that Baldwins had, and Rob had the trial before the judge, and the judge did find, as a matter of fact, that testimony is credible. So there is an established date on which the Baldwins filed the tax return. It was June 21st, 2011. But 2 months later, as Rob was mentioning, the IRS changed its rules and then refused to give a refund to the Baldwins. And that's why this is a classic Brandex situation, because you have the common law rule on your side, on the Baldwin side, you have a statute that's on the Baldwin side, and you have some 20-something-year-old case from the Ninth Circuit where they live, it's California, which clearly says you can use this kind of extrinsic evidence. So we have all of these things on one side favoring the Baldwins, and on that basis, Baldwins won. They got a district court judge to tell them that, yes, you are entitled to this tax refund of $170,000 something. Then IRS takes the case to the Ninth Circuit and says, but wait a second. We have something called the Brandex Deference Doctrine, under which we can basically ignore the Supreme Court's, the Ninth Circuit's decision, and we can instead apply our own regulations, and that court should use our regulations, defer to our regulation, and reverse the trial court's decision. And that's exactly what the Ninth Circuit did. So, Bob, let me ask you, why is this important? Why is Brandex, why is it important for us to take a look at Brandex? Why should people care about this?
Well, because this goes really to you might say, the intersection or interplay between administrative law and the judicial system that's set up in the Constitution. As Ari mentioned, I teach the administrative practice course at Georgetown Law School in the Master of Tax program. Tax seems to be setting some of these precedents now. I spent an entire class on deference, which goes all the way back. And without going into too much detail, some of the evolution in the tax area is very interesting, because back before 2011, there was a separate rule. We used to refer to it as tax exceptionalism, where in an old Supreme Court case, 1979, called National Muffler, came out with a 6-factor set of tests on when a regulation, a Treasury regulation, is valid, and one of which is how contemporaneous is it with the statute, and did Congress think about this? I mean, so it was a factor by factor. It was not the step one, step two. And interestingly, so this was before Chevron, and interestingly, Chevron did not even cite National Muffler when it laid out its 2-part test. And in the intervening years up to 2011, which is a coincidence as to these regulations, the same date, in 2011 they put out a case, Mayo Foundation, which said this is the end of tax exceptionalism. Now tax regs will also be subjected to Chevron. And before that, and in that decision in Mayo, they even noted that the court itself had flipped back and forth between National Muffler and Chevron in between without even noting that they were applying from time to time different decisions. So this has been a very confusing area in the tax law, but since 2011, now everybody is under Chevron. So I mean, I think this becomes increasingly important because historically, I guess in all areas, certainly in the tax area, the split of circuits, it was not at all uncommon. As you might have, I'm not trying to say tax is the most complex area, but I think most people concede it is reasonably complex. It was common to get circuit splits. And the typical way this was resolved was by the Supreme Court or by Congress. And the IRS has no trouble getting access to Congress if something is important. So in a circuit split, if the government lost a case they thought was important, they would set it up in a different circuit. They would, and usually there was kind of an informal three-circuit rule. If we lose in 3 circuits, we give up if we haven't created a split. But there was one a long time ago, I can't remember the name, I think it was an ERISA case. They actually went to like 8 or 9 circuits before, and lost before they said, okay, enough, we give up. So this was the traditional way of resolving it. What's also interesting, the home concrete case that's in the cert petition, you know, there the government tried to overrule a Supreme Court precedent, and of course said, well, now you've really gone too far. They really did overreach a bit. But the aftermath of that, and of course they lost. They said that the Treasury reg that was going to change the case, the rule in the case called Colony, would be. They weren't going to allow that because, by definition, Colony, the Supreme Court had made it unambiguous, and so the regulation was not was thrown out. However, interestingly, the exact issue in Colony and in home concrete was changed by Congress. So after that, they went to, instead of just trying to throw an administrative reg in, they went to Congress. Congress agreed, and they changed the rule by statute. Nothing wrong with that. These aren't constitutional rulings; these are statutory rulings, and you don't have to have a constitutional amendment to change it. You just get it passed by Congress, and that is what they did. So I think what we've seen is historically it was not that difficult to get these types of circuit splits resolved either by Congress or by the Supreme Court, and people exist for a long time in different circuits having different rules. But it seemed that that in this case, they just wanted to just drive over it. And I know we're trying to stay on a schedule here, but I'll just say one more thing about the preamble to these regulations. Interestingly, when commentators said, you know, you should keep the common law mailbox rule as an alternative, in the preamble to the regulations of 2011 that put this rule in, the Treasury stated, the Treasury Department and the IRS cannot adopt regulations extending the prima facie evidence of delivery rule to first-class mail. I have never heard the Treasury admit that they couldn't do anything they wanted to in a regulation with the broad deference given in Chevron to permissible reading or reasonable reading. So that I thought was very interesting as to what they were not really addressing what they were really doing. So they'll try to say, well, we're trying to avoid splits of circuits or having having different rules apply to different taxpayers. But my point is that happens all the time. It's been resolved, and I was struggling to think before this meeting as to when I could think that they took a circuit split that didn't really involve an ambiguity in the law. And I think that's a good point brought out in the cert petition. This is not an ambiguity in the law. They're trying to say because Congress was silent on in the law, that we're intending to overrule the common law. Therefore, because they're silent, that somehow creates an ambiguity in the law. And then and the circuits that split, well, we'll resolve that with an administrative regulation. So that's why I think this is really important, and I think it, from my experience, is reasonably unprecedented.
Yeah, I think you touched upon two important themes there because, so one of the things is this Brandex switch. So it's almost like an on and off switch in that sense, because if an agency is claiming Brandex deference, what it's really saying is we had a court decision which was first in time, and second in time we have the agency regulation that ignores or overrules the court's decision. Now you should be giving Chevron deference to the court, to the agency's regulation. So Brandex acts sort of like an on-off switch, which switches on Chevron deference or switches off Chevron deference. And here, of course, I mean, it didn't just, if you read the Ninth Circuit's opinion, it isn't just switching on Chevron deference, it's skipping a part of that inquiry. It's not looking at the statute at all. They are saying, well, back in the day in 1992 when the Ninth Circuit looked at this, they didn't really say if the statute was silent, was it ambiguous, was it unambiguous. So we'll just assume that the agency's interpretation in that circumstance is reasonable. So for those of you who are familiar with Chevron, there's two steps. The first step is you look at traditional tools of, you look at the text of the statute. The first thing you're supposed to do is read the text. But here it seems like the Ninth Circuit skipped that text, that first step, and went directly to say that the agency's new regulation, the 2011 regulation, is reasonable. And the other theme, Bob, that you brought out was this circuit split issue. And to that, I just want to quickly mention that there was a circuit split on the question of what this tax statute does. So there are several circuits, like the Ninth Circuit, the 10th, the 8th, and one more I forget, who have said you can use extrinsic evidence. And there are a few circuits, like the Second Circuit, that have said you can't use extrinsic evidence to prove these things. So here, IRS stepped in to resolve that circuit split. So they stepped in to say, okay, we have circuit courts disagreeing on what the statute means or how it's supposed to apply in a timely filing, untimely filing situation. So we will just come in and resolve these circuit splits. So Bob, I want to ask you, can IRS resolve circuit splits?
Well, what I thought of one way that they could help taxpayers who are maybe in a circuit split situation is to simply put out well, first of all, whatever circuit you're in, that rule should control. If you're in a circuit that doesn't have a rule, I don't see any problem with the IRS putting out, and we call it sub-regulatory guidance, and this could apply to any agency, where it's guidance, and it's revenue rulings, revenue procedures, other types of guidance, for which they do not claim Chevron deference. And in fact, the head of the appellate section for the Department of Justice said that in those situations for sub-regulatory guidance, they will not claim Chevron deference, and they had a recent Treasury news release that said that. So there's nothing wrong with putting out sub-regulatory guidance, some kind of just a press release, whatever, that says to taxpayers as guidance, if you do this, use registered mail, you're okay. If you don't, we will consider it to be not timely filed. Then at least the taxpayer is on notice if they live in a circuit that doesn't have a rule, and that could be helpful. So you don't get, but on the other hand, if you're in a circuit that does have a rule, you should follow the rule. And I don't see those two things as being inconsistent myself. In fact, I said taxpayers could be helped by sub-regulatory guidance, but to try to overrule a court in a circuit that has the rule, that is where I think they've really gone over the edge, somewhat like they were trying to do in home concrete. Mm-hmm.
Right, and that's really a separation of powers issue too, because I mean, if you look at it, you have an Article 2 agency, an executive agency is under Article 2 of the Constitution, that's overruling an Article 3 court's decision, and that is, in Justice Gorsuch's words, more than a little problematic. And I was actually reading his most recent book, A Republic If You Can Keep It. I'm maybe halfway through it. And he uses the analogy of a triangle, which I think is very helpful in kind of explaining the separation of powers issue. He says, we have a tripartite structure, and imagine a triangle. And one node of the triangle, the judiciary, has given a decision. Now, that can be overcome only by the other two nodes of the triangle. So you could have an act of Congress, so it has gone through bicameralism and presentment, so Congress has enacted it, the president has signed it into law. So that could overturn a court's statutory decision. Now, court's constitutional decisions are a separate category in this situation. And we aren't dealing with a court's constitutional decision. We are only dealing with a court's statutory decision because they are interpreting Section 7502. So you need two nodes to overcome the decision of one node in that triangle. And here it's one single node, an Article 2 agency overcoming an Article 3 judge's decision. And that's what causes the separation of powers issue, because it circumvents the checks and balances that are part of the structure of the Constitution. So I think Justice Gorsuch's analogy in his book is helpful in explaining the separation of powers situation. But I think to the broader point, this is not just a tax issue. This is a broader issue. I think you had mentioned that in your op-ed as well. And Bob, I want to turn to you. Rob, excuse me. And I know it.
Keep us straight.
So Rob, I want to ask you: is this lack of uniformity something that's unique in the tax context? I mean, is there a broader principle involved here? I mean, you have litigated this case from the very beginning. You have seen these arguments fleshed out. So tell me the wider implications of this.
Yeah, the wider implications of this Ninth Circuit case is that whenever a statute is silent as to its impact on common law, an administrative agency now has the ability to come in by way of regulation and repeal common law. That's essentially what the Ninth Circuit held in the Baldwin case. They flipped the general rules of statutory construction on its head, because the general rule is that if a statute is silent on whether or not it repeals or supersedes common law is presumed to still apply. And so what the Ninth Circuit did in this case is they said, well, 7502 doesn't specifically say whether or not it's repealing common law. Therefore, there's a gap that the Treasury can fill by coming in and repealing the common law mailbox rule. Now, the problem with that analysis is that because the statute is silent, that means that common law is presumed under the general rules of statutory construction to still apply. And when that analytical framework is applied outside of the tax context to any statute, the administrative agency can now come in and say, well, this statute doesn't address its impact on common law, and therefore there's a gap to fill, and the administrative agency can now come in by regulation or ruling and determine that common law does no longer applies with respect to the issues raised by this statute, which is a huge power grab in my mind.
Yeah, I think that's another important theme that this case presents, is this idea, and Bob, you also touched upon this a few minutes ago, is this idea of, there's really three different things that are happening when a court is looking at a statute, at the text of a statute. Now, the court can come in and say, the statutory text is clear, it's unambiguous, and that's what the statute means. Or the court can come and say, you know what, the statute is really ambiguous. I mean, we don't know exactly what it means. Now, again, I keep going back to Justice Gorsuch because I hope we get his vote in the cert petition. But he likes to use this analogy. So if you ask like a person on the street, if I tell you I want to meet an actor, director, or producer of a Star Wars movie, whom do you think I want to meet? Now, the person might say, well, you want to meet an actor that acted in the Star Wars movie. You want to meet a director that directed a Star Wars movie, or you want to meet a producer that produced the Star Wars movie. Or, I mean, if someone is a fan of the Oxford comma, you would say you want to meet an actor. It could be Jamie Foxx, it could be whoever, who had nothing to do with the Star Wars movie. You want to meet a director, or you want to meet a producer of a Star Wars movie. So those are two kind of competing interpretations, and there are legitimate places where statutes are ambiguous, and courts have maybe dealt with that under the void for vagueness doctrine, and there are several ways that courts have dealt with it. So that's kind of like the second kind of broad category of statutes that courts have to evaluate. And the third category is this statutory silence. And that's really what's happening here, Bob and Rob, because so you have every circuit court that looked at this statute, saw the words U.S. mail, and saw the word postmark, and saw the word delivery date. And everyone said the statute, it doesn't really say what happens when there is a timely filing issue. Can you use extrinsic evidence or not? And that's where the gap filling really comes in. And in that gap filling, really the question for a court, I mean, not just in this case, but the broader question is, does the common law fill that gap? Or is the statutory silence give an agency like the IRS to fill the gap with whatever it wants? Now, there's a famous presumption which, Rob, you have argued in the Ninth Circuit, and I thought at first that the Ninth Circuit would be jumping on it because that's a very easy way of resolving this issue, and that's the common law presumption canon. So the common law presumption canon is a traditional tool of looking at statutes that says, if you look at this statute and you can't figure things out, if the statute is truly silent, then we presume that Congress knew the common law backdrop in which it enacted the statute, so the common law is applied to fill that statutory gap. So there isn't really a gap to fill. It's really, silence is closer to a statute being unambiguous than it's closer to a statute that is ambiguous. But the Ninth Circuit here said, silence is kind of closer to ambiguous, and therefore, we should be giving deference to the agency. So, Bob, you have expressed some interesting views on gap filling.
Well, yeah, and I think one thing that, and again, I stress this with students. You look at all the Supreme Court cases. There's been a lot of Supreme Court cases, both in and out of the tax law. But I thought, and we spoke a little bit before about one interesting case that came down in June, Keister versus Wilkie, a non-tax case involving veterans' administration rights of a veteran. But Justice Kagan wrote, and that involved what I call double deference, where they try to get deference to an administrative interpretation of an ambiguous ruling, ambiguous regulation. So it's like deference to an ambiguous regulation, their interpretation of it, which is then entitled to Chevron deference as well. This called Auer deference, A-U-E-R. And everybody thought that, well, a lot of people, myself thought too, that the court might use that case to just throw Auer deference out, an administrative agency interpreting its own regs. Instead, Justice Kagan wrote a very good opinion with like 5 hurdles. And it's like, if you can get over all 5 of these hurdles, you deserve deference. It was almost like, oh, I'm not done yet. It was it was really somewhat amusing, at times. But rule number 1 she used was using the full toolbox of interpretative techniques for legislation. And I think that was a nice, in terms of whether or not it's ambiguous in the first place. Use a standard toolbox, canons of statutory construction in interpreting whether an administrative regulation is ambiguous, which would be the first step to get you some kind of deference to an administrative interpretation of that regulation. And I think here, why would that not also be the case? Because if you apply the common law toolbox, or the canon of constructions, normal canons of constructions, you would, I think, as you just pointed out, you would get to the point that you can't really say because it's silent and the common law can't apply.
Mm-hmm. Yeah, and I like the phrase you used, full toolbox.
Full toolbox. I can't take credit for it.
And Rob, I want to turn to you. And you had argued in the Ninth Circuit that there are several tools in this toolbox. So there's the common law presumption canon, and there are several other tools that render the statute unambiguous. So tell us how this common law presumption canon kind of factors into this analysis. Like how do you use that kind of a tool? So if you're telling a judge or a justice that this is a traditional tool of statutory construction, how would that play out in this context?
Yeah, the way that we articulated that in the context of the case, both in the district court and before the Ninth Circuit, was that the silence with respect to the impact of 7502 on the common law meant that the common law still applied. And one of the primary arguments that we made was that Justice Pragerson, who wrote the majority opinion in the Anderson case had made that finding specifically in the opinion. Justice Pragerson found that because the statute did not specifically find that the common law was being superseded, that there was no intent on the part of Congress to supersede or otherwise repeal the common law mailbox rule, and therefore the taxpayer in Anderson was entitled to rely upon the common law mailbox rule to prove that they had timely filed their tax return.
Yeah, and that also kind of really goes to this idea that before Brandex was decided, Brandex was decided in 2005, and we have the Anderson decision, which was decided in 1992. Back in the day, like before Brandex, courts did not have any inkling that they should be using kind of these magic words, ambiguous, unambiguous, silent. No one really said that. I mean, basically the courts did what they typically do. They look at the statute and say, this is what it means, and they apply that in a straightforward fashion. But Brandex comes in and says, oh, you have to, sort of start using these magic words. So in this specific instance, we are dealing with a situation where the previous court, the first-in-time court, did not use magic words. So the question for now, the reviewing court, the Baldwin court, the Ninth Circuit, was, what did they mean back in 1992? Did they mean to say that the statute is silent, or is the statute not silent? And that, I mean, you can imagine like it kind of like has the potential of going into infinite regress, because I mean you can't like read the tea leaves at that point, what the previous court meant to do, and that's another kind of principle of any body or entity overruling a previous court's decision. Now, typically en banc courts, meaning a panel of 11 judges, 15 judges, can overturn a 3-judge panel's decision, or the Supreme Court can overturn a Ninth Circuit, 6th, 7th Circuit Court's decision. But here, Brandex kind of like flips all of that and says, no, the agency's interpretation survives. So, Bob, you were mentioning home concrete and colony, and the court kind of used some interesting phraseology, let's say, in home concrete, because the previous case in colony had said, well, the statute is not unambiguous. It was one of those double negatives.
Sort of double negative. Yeah.
And then Justice Breyer in home concrete said, well, that really means that now it is unambiguous, and therefore there is no gap to fill. So tell us about home concrete.
Justice Breyer was very concerned about the government using regulations to overturn the Supreme Court. But if I could just extend that one step further, one thing I have thought of just logically, how does this work? How does Brandex work? If you have a circuit split on whether or not it's ambiguous, which you could have. So one court says, I think it is not ambiguous, and therefore Chevron does not apply. Another circuit could say, I think it is ambiguous because they're not, and so Chevron does apply. And so then when you go up, how do you go up to the Supreme Court? Are you going to is the Supreme Court going to resolve whether it's ambiguous or not, and therefore, I mean, that would be silly. And they're not actually looking at the statute anymore. They're just looking at whether it's ambiguous or not, and then apply Chevron. I think the whole concept of this ambiguous, unambiguous, just doesn't work. And home concrete, could have maybe done better in terms of shoving it aside, but they were really just limiting that to the Supreme Court as I read it.
Yeah, for sure. And even Brandex, I think it was Justice Stevens who wrote a concurrence. It was maybe like a 4-sentence concurrence, yes, in which he said, so he joined the Brandex majority, and Justice Stevens said, we don't mean to say that agencies can overturn U.S. Supreme Court decisions, so please don't read Brandex as overturning Supreme Court decisions. So it's kind of one of those questions that's up in the air, and it came up in home concrete.
Well, the government tried to avoid it by saying it. I mean, technically, it was a iteration of an earlier statute that was reenacted with slightly, and they were trying to say, this change means it's a different statute, so it's not really the same statute that was interpreted in colony. Well, the court blew that one by and said, no, it actually is the same statute, and so therefore it is not ambiguous because we told you what it meant, and so and so forth. But there again that was a situation that was arising what was called the tax shelter wars back in the, and the courts wanted to try to find ways in general, and Treasury was that's why they overreached, and like most cases where you overreach, you end up getting burned, and that's what happened to the Treasury in the home concrete case.
But they did not get burnt enough that they would stop using Brandex or other deference doctrines. So here, I mean, home concrete and colony, I mean, really kind of sets up one of the principal points that we made in the cert petition, that really, if you look at it, Brandex subverts stare decisis. And the reason for that is because, any agency can come in and overturn a court's decision, and justices who are interested in maintaining a strong stare decisis doctrine should actually be against Brandex, because it kind of, you have stare decisis on one hand and Brandex on the other, and stare decisis, would instruct courts that, court decisions don't get overturned without any special justification. But Brandex, of course, allows agencies to overturn court decisions so long as that is reasonable. So, I mean, special justification is, some really good reason for overturning a court's decision, whereas Brandex allows, agencies to come up with any conceivable reading that's reasonable, and that's okay. So there's a tension between Brandex and stare decisis, and we make that point. I think, that's a principal point that should, attract at least 4 votes in the U.S. Supreme Court. So I kind of want to touch upon this idea of, kind of going back to our discussion on how Brandex is kind of switches on Chevron deference. What do you, and this is a question for both of you. I'll go with you first, Bob, and then Rob. What do you think is the solution? What do you think? I mean, we have, let's say, a previous court's decision that has applied traditional tools, the full toolbox, the Keister toolbox. A court has faithfully done that. And now we have a Brandex situation where the agency has completely ignored that. What should the Supreme Court do? So imagine if, we are in the Supreme Court with the Baldwin case. What do you think is the solution there?
Well, again, as I suggested, I think they should draw the line at overruling court decisions by administrative regulations. And I think what I suggested a little while ago, if they simply said, if you're in the circuit that has this rule, you follow that rule. If you're in a circuit that follows a different rule, you follow their rule, until we resolve it. And the government, as you know, gets great deference. When the Solicitor General files a cert petition, I don't remember the exact numbers, you may know better than I do, but I haven't looked at it lately. But the percentage of granting of government-initiated cert petitions is very high, because the court knows that they screen them very carefully. So the government has a much lower hurdle to get over to get into the Supreme Court. But I think it would be a good idea for them to give guidance, some regulatory guidance, to help people who are in circuits that haven't reached a conclusion. But for circuits that have reached a conclusion, I think that those rules should apply until Congress changes the rule, as they did in home concrete, even, or it's done by the Supreme Court.
Rob, thoughts on it?
Yeah, I agree. I think that the proper place to resolve a circuit split is either in front of the Supreme Court or Congress, and that administrative agencies should not be afforded the right or the power to overrule circuit court decisions merely because a statute is silent on its impact on common law, which is what they've done here. I mean, I think that that's a huge problem from the perspective of people that are litigating with the government.
That's even a bigger problem in this case, because there's not an ambiguity in the statute. They're creating the ambiguity, as we said earlier, but by saying the statute's silent. So I think that's an even greater hurdle of overturning court decisions than if you had a situation where different courts were agreeing or disagreeing as to whether the statute was ambiguous. Just looking at the statute itself, that is.
And I mean, I like to, on the silence point, I like to give this example. It has too many kind of unintended consequences if you really think of it, but for our purposes, I think it works. So all of us have been teenagers at some point, or we have teenage kids. And if you tell a teenage kid, we are going out over the weekend, you take care of the house. All you say is take care of the house, and does that mean that I'm totally silent on what the teenager is not supposed to do? Does that mean the teenager can then have a party over the weekend?
Yes.
If you're the teenager, not if you're the parent. But that's essentially what's happening. I mean, Congress, let's assume Congress is truly silent on this, and they haven't instructed the agency one way or the other what they're supposed to do. And if the agency is like our unruly teenager, assuming they can do anything they want, then that's an issue. And that's really the proper, avenue for the courts to decide, what the statute means. And if they decide, your proposal is, we could have a circuit that does not have any rule because the court hasn't said anything. And then we could have circuits that have rules, and we just follow the circuit precedent. And then for circuits that don't have anything, IRS can come in and fill in.
Sub-regulatory guidance, and if they did that, and then it goes to court, the Court of Appeals, or any court, is not bound by the sub-regulatory guidance because the government agrees Chevron doesn't apply. So the court can then decide, based upon how the other circuits have lined up, what their rule will be. And that is, I think, the way it should be, under Article 3.
Touche. So I do want to have a chance for all of you to ask questions, so why don't we turn to that?
Can I take the first question?
Please.
Bob, you mentioned this point a couple times. I wanted to push back on it a little bit. The idea that sub-regulatory guidance from the IRS could guide the taxpayer in a circuit in which there wasn't a clear court rule. And here at New Civil Liberties Alliance, we're very anti-guidance for a lot of different reasons. But in this particular situation, I would suggest that sort of sub-regulatory guidance would be trying to bind the taxpayer. And I think you would agree with me that guidance can't bind the actions of a taxpayer.
I didn't mean to give that impression. What I'm saying is a taxpayer would have certainty if they wanted to follow the sub-regulatory guidance that they would not be challenged.
I see.
That's all I'm saying. And that's what any sub-regulatory guidance really means to maybe that's a term that's not commonly used. But to a tax lawyer, sub-regulatory guidance means this is what the government's position is. It's a publicly stated position for guidance. If you follow it, you're okay. If you don't follow it, you take your chances.
You might have a court case on your hand.
Exactly. I hope that doesn't violate your principles, but that's it's purely voluntary. That's the thing.
So one thing that struck me in the description of the case, that an element that may not be present in other Brandex challenges is the retroactivity of the new rule. So if I got it correctly, it sounds like the taxpayer acted in reliance on the common law, and then after that, the rule came down, saying that you can't rely on the mailbox rule anymore. That seems to add, to make this an even more egregious instance of Brandex, and I wonder, in your cert petition, have you argued that even if Brandex is appropriate for some circumstances, that this is a case that should be excluded from Brandex?
That's a very good question, and I want to answer that, but I also want to turn to Rob for part of the answer. In the tax context, there is a specific statute, Section 7805, which Rob has much more experience than I do in dealing with it. But the short answer to the question is yes, absolutely. I mean, the retroactivity question probably makes this one of the most egregious situations that we have seen, because at the time they filed the tax document, they had no way of knowing what the rule was. I mean, they look at the statute, they look at the Ninth Circuit precedent, they look at the common law, and they look at the old version of the same regulation, which says, yeah, you can use any sort of U.S. mail methods, regular, registered, certified, etc. So that's what they follow. But then the IRS claims, no, later on we changed the regulation, and that's what you should have followed. So in effect, I mean, the practical effect of that really is that they're asking for deference to a notice of proposed rulemaking. Because the IRS's position is, well, in 2004, we had this notice of proposed rulemaking in which we had proposed this exact same rule that we are only going to restrict mailing methods to registered and certified mail. So you should have followed that. And too bad you did not follow it. So we do mention that in the cert petition that is absolutely not okay. Because, I mean, there's no such thing as deference to a notice of proposed rulemaking. That's not the law. That's just a proposal that the IRS has put forth.
It is somewhat circular, though. As you pointed out earlier, there is 7805B of the code does allow retroactivity to the proposed date. So it's somewhat circular that then they're saying, so are you relying on a proposed reg because you don't know what's going to happen later, if it will be finalized, if it will ever be finalized. But if it's finalized in substantially the same form, there is some statutory basis for retroactivity in the tax area. But now that only applies in the tax area. So what happens to other people? So that's why this case obviously has implications well beyond the tax area.
Oh, absolutely,
Yeah.
yeah. And Rob, I want to turn to you because you have dealt with the Section 7805 situation.
Yeah, so one of the arguments that we made in the Ninth Circuit is that even if the Treasury regulation should have been afforded Chevron deference that has applied to the Baldwins, it should not have been retroactively applied because the regulation became final after they mailed the 2005 amended return. The way that the Ninth Circuit dealt with that is to cite the statute that says, in general, the IRS has the ability to issue final Treasury regulations that are retroactive back to the date that the regulations are proposed. Right. The problem with that analysis is that there are still constitutional limitations on retroactively applying final regulations, which the Ninth Circuit just simply ignored. There's a Montgomery Ward's case in the Ninth Circuit that goes through a 5-factor balancing test. One of the major factors is how long has the rule that the taxpayer relied upon been in effect, which in this case is, probably 100 years. The prejudice to the taxpayer, there's a long list of factors that they look at. But the Ninth Circuit didn't even attempt to apply those Montgomery Ward factors, which is controlling law in the Ninth Circuit.
Mm-hmm. And that really is the underlying theme of the case, to answer your question, is there is a significant due process problem with this, a separation of powers problem with it. If anyone is interested in that issue, it would be Justice Gorsuch, because he has 2 significant opinions that he wrote when he was on the 10th Circuit, the Denise-Robles decision and Gutierrez-Brizuela, in which he specifically tackled the retroactivity question. So we do mention it in the brief, and the hope is that that will capture his attention, and he may do something with it.
What would be the motivation for the IRS in this? Because wasn't it about a 2-month period of time before that regulation went into effect? Why have they gone to the mat with a case like this? Rather than just simply stating the rule wasn't in effect, the mailbox rule applies, we'll go on with life.
That would certainly be the easier and the more rational course for the IRS. But I think it's really the question for both of you, because you have dealt with the IRS more than I have. So
well,
Bob,
I can tell you what they told us in connection with the case, because we tried to resolve the case on numerous occasions with the IRS. And at no point in time did they ever, even after we won in the district court, did they ever offer a penny to resolve the case. They claimed that they wanted a resolution as to whether or not that regulation was effective or not. That was at least their stated position, that, it was more important than just this case. They were looking for a ruling from the Ninth Circuit as to whether or not Chevron deference applied and whether or not Brandex applied, so that they could then use that to deny other taxpayers the ability to use the common law mailbox rule in the Ninth Circuit.
And that's common in tax litigation for the government to oftentimes spend 10 or 100 times more on a case than it is worth in terms of its monetary amount, because of they view it as a controlling principle that they want to establish. And they test it as whether this is a proper vehicle to do that.
And that's another kind of worrying thing, because if the IRS is using, regular taxpayers as test cases in some kind of a social experiment, some legal experiment, I mean, that in itself is bothersome.
That's an old problem, yes.
You mentioned how this is a particularly egregious case, and it's got some very unusual circumstances to it, like the retroactivity and other things that most other cases wouldn't have. What do you think the chances, even if you are successful, what do you think the chances are you'll have a narrowly tailored decision to resolve the sort of very specific cases that might fall in these circumstances, or one that, like you said, would overturn Brandex deference entirely?
I think the way that we have phrased the question makes it a broader issue. I think that the simplest and the easiest way for the court to tackle the issue really would be to take a look at at Brandex itself and see if that has any continued validity. I mean, this is the perfect storm, I like to say, in that sense, because this is clearly a Brandex issue. We clearly had centuries-old common law rule. We clearly had a statute. We clearly, had a court decision that directly applied on this specific point in the Ninth Circuit. So Brandex, I mean, is front and center in that sense, and it truly is outcome determinative. I mean, Rob got the Baldwins their money back in the district court because the district court did not apply Brandex. But then in the Ninth Circuit did, and it reversed that award of the tax refund. So there's clearly Brandex is what's causing this difference in the outcome, and we see that clearly in this case. So I think if the court were interested in tackling the validity of Brandex itself, I think this would be the case in which they have an easy, straightforward way of doing that. But we also make sort of a lesser included and a secondary argument, if you will, and that's essentially asking the court to do something, to take this case and do something that, like they did in the Keister case. They said you have to use this toolbox, you have to use traditional tools of statutory construction. And there are several tools here, the common law presumption canon, the contra preferentum canon that's used in the tax contest. So there are several US Supreme Court cases that have said that tax statutes are to be construed in favor of the taxpayer. And here it's the exact opposite that the Ninth Circuit did. So there are several canons of traditional tools of construction, these tie-breaking rules, if you will, that give the court an easy answer. So I could see the court, saying, okay, before you decide whether Brandex applies, you still have to do the traditional tool analysis. So that would be another way for the court to resolve this, and it would be, it would be a decision that applies well beyond the tax contest. It applies anytime a Brandex situation is in play.
I wanted to ask another question about the fact that there's the common law angle at play here. You guys talked about this issue a little bit, but I think two of the things that bother me about this are, one, that it's actually easier for an agency under Brandex to overturn the common law than it would be for Congress to overturn the common law, because courts have, because of the presumption canon, the court forces the legislature to speak clearly if it wants to overturn the common law, but they're not forcing the agency to speak clearly to overturn the common law. And they're also, I mean, aside from the separation of powers problem that you mentioned earlier, that it's just one agency overturning one other branch of government, you also have the problem that in this case, like the common law mailbox rule in particular, seems to me, if the common law mailbox has been overturned by the IRS, what does that mean for the common law mailbox rule for every other agency out there? And I would just throw that open to you guys to answer, because it seems to me that if a court were to rule on the common law mailbox question, this wouldn't be, I think you would assume that the common law mailbox rule has gone away. But when just an agency does that, typically courts don't allow agencies to rule on things outside the scope of their agency's charge.
Yeah. And you're right. I mean, the common law presumption canon, what it does is it says, Congress has to give a clear statement that they are intending to overturn a common law rule. And Congress has done that in several occasions. In the cert petition, we mentioned several statutes in which Congress has restricted methods of delivery. So they have restricted mailing to registered or certified mail. They have insisted that the postmark date should not be the delivery date. The actual delivery date should be the delivery date. The best example is mailing ballots, early ballots. They have to reach the citizen at before a certain date. So they have overturned the common law mailbox rule in that sense, but there is a clear statement there in those statutes. There is no clear statement here, and you're absolutely right. The IRS is now coming in and not having to give that same level of clarity or that same level of thoroughness, if you will, when they overcome a common law rule like the common law mailbox rule. So we can take maybe one more question, but Bob and Rob, any final thoughts? Rob, I'll start with you.
I guess just emphasizing what you said, I agree that the IRS does not have any expertise on issues of proof. And that's essentially what they've done in connection with this regulation. They've set forth the only methods of proof by which a taxpayer can prove timely filing of a tax return that's not received by the IRS. That is not something that the IRS has any expertise in. And that's another reason why they should not be given deference in connection with this case.
Yeah, and I would follow up on that. Absolutely. If you look at the final sentence of Brandex, the court basically says it's relying on the agency expertise. And this does not involve agency expertise. So however Brandex goes, the question is to what extent should agency expertise be taken into account?
Absolutely. I mean, as Rob was saying, I like that. I mean, they just don't have expertise in methods of proof. I mean, that's rules of evidence. I mean, that's the court's job to enforce all of that. And there are a long line of U.S. Supreme Court cases where, for example, the court has said, for example, the National Labor Relations Board doesn't have any expertise on common law concepts like agency principles, like principal-agent relationships, like employer-employee relationships. They don't get to define those things because that's a traditional function of the courts to, have an exposition on the common law. So I mean, yes, that is a powerful argument, and our hope is that we'll get there. So please join me in thanking Bob and Rob. Thank you.